All right, everybody. Thank you for joining us on our weekly Zoom and Learn on Monday, our Monday weekly Zoom and Learn. We are so grateful that you all are here. We have a full house today, which isn't surprising because we have a topic that comes up all the time. So I'm very excited about this. My name is Tommy Dutcher. I'm the area sales manager for California Title Company. If we have not had the opportunity to speak about your business, I would love to have a conversation with you and be able to dissect your business on how I may be able to help you grow your business. I am fortunate because I have people surrounding me that are from Granite Escrow today that are as knowledgeable as they come. And I always say, if you can surround yourself with people that can help you, it is a benefit. And Mary Jane Morris is one of those individuals. MJ, would you like to introduce yourself and your team?
Hi, everybody. I'm Mary Jane. I'm the Temecula Riverside sales rep for Granite Escrow. I am a retired escrow officer and I was a broker for 20 years as well. I just celebrated my 40th year in the business. I was ready to retire when Granite said, why let all that go to waste? And he brought me out in the field. Hi, Jonna. Nice to see you. Hi, Tracy. I'd like to, Granite brought me on purpose so that we could do problem solving at a higher level for the things that are just routinely known and the things that an escrow officer doesn't have time to, or necessarily the education. So to answer on which form you're going to use on car or that sort of thing. So I'm very grateful that they let me be who all I can be here, and I'm happy to be here. I'd like to, before I introduce our guests, I'd like to introduce Tracy Hussey from our Mission Valley office. Good morning, Tracy.
Good morning, everybody. Thank you for being here.
Yes, it is now. We just make it past noon, and every time I say good morning. I hope you're having a nice day down there. And hi, Miss Jonna from our La Jolla office. So I, over the years, have considered myself a collector of people. Back in the day, some young people don't even know what a Rolodex is, but back in the day, you collected things and cards and sources and people who knew how to fix problems. And I was fortunate this year to add Andrew Wertheim to my team of experts. And we have offered many times for a lawyer to join our little group here and spend time with us and get to know us. And Andrew specializes, I'm gonna let him introduce himself too, so he'll do a better job, but he specializes in estate law and business law. I've asked him to join us on Mondays and throw his spin on it, and also to give you guys exposure to a local attorney. And I've had a lot of luck with throwing him. I warned him right from the beginning that I'll throw him everything I've got, no matter from weird grant deeds to true estate situations, and I've positively done that to him. So I have absolute confidence in him. Today he's going to talk to us about LLCs, the good, the bad, and the ugly. Yes, Andrew?
Yep.
All right, welcome to the show. Tell us about yourself, and Tommy will make you the presenter, and we're off and running.
Sounds good. Well, my name is Andrew Wertheim. I'm a California licensed attorney. I'm a patented inventor, but I actually decided to proceed with law rather than move forward in those inventions. Basically, when my daughter was born, it changed everything for me. I got my first estate plan, and it's a full 180 turn. But I'm here to talk about LLCs today. I just want to make sure that we can, do I need to share my screen, Tommy, or is everyone able to see the PowerPoint?
Yeah, if you share your screen, everybody will be able to see it.
Okay,
perfect.
How's that? Can we see it now?
Yes.
Good. So Pacific Estate Planning PC is my professional law corporation. And to give the typical lawyer disclaimer, unfortunately. So I am a California licensed attorney. Obviously, I'm here talking to you. This is not legal advice, though. This is done for educational purposes only. And the main reason for that is every case is different. And it really takes personalized attention to get it right. So I am not your attorney, and watching this video does not create an attorney-client relationship between the two of us. However, I am here to help. And if you would like to call or email me after this presentation, I would love to see how I can help you. Okay. So how do we do this? All right. LLCs, what they don't tell you and why many of them fail. First, I want to go over what are the advantages of an LLC, because they are many. And the principal advantage is liability protection. Especially if you have real estate investments and you have a business where you're exposed to personal liability, I want you to get an LLC. Picture anything that you're doing that's business related. Can somebody get hurt? Can they suffer property damage? Can they get sick as a result of your business? If any of those answers is yes, then an LLC is a great asset protection tool to have in your toolkit. All sorts of problems can happen with real property, can't they? We could, from mold to lead poisoning, we could have a structure collapse. We can have someone slip and fall. A kid could drown in your pool. Your investment property could be burglarized and your tenants' lives could be in danger. All sorts of crazy things can happen. Last year, I had a client who rented to a tenant. The tenant found mold in the home and the tenant ignored the problem for quite a long time. Long enough for the mold to spread and ruin all of their clothes. Bad tenant? Probably, but it still hurt the landlord, my client. The tenant suffered a heart attack while he was living there. And of course, he didn't blame his lack of exercise or the food he ate. He blamed the mold. And the day that he returned from the hospital for the heart attack, guess what he chose to do? He chose to break the lease and move out that afternoon. And in the rush to move out of the property, he suffered a stroke and he slipped and he fell. And that's when the lawsuit started. Okay, so having liability protection is so important. And insurance is important too. I actually really love insurance, but insurance isn't always enough. Either you don't have enough money in the bank, usually we get maybe $1 million of insurance. And if it's a serious injury or if multiple people get injured, that $1 million may not cover the full amount. The other thing to look for is exclusions to coverage. They're not going to insure every possible scenario. So insurance is very important, but limiting your liability in the first place through an LLC is also equally powerful, and it's best to do both. So how does it work? How do we get this personal liability? The general rule is if you follow the rules of the business structure and you keep your books done properly and you have a separate bank account and you keep track of your receipts and other business records, then you will get personal liability protection. Incredibly powerful. To kind of drive this home, if you don't have an LLC, right? Let's say you have an investment or property and your investment property is under your name. Let's say it's Joe Smith and someone slips and falls in your home. They are going to sue Joe Smith. They will be able to attach to everything that Joe Smith owns, his retirement accounts, his bank accounts, his other business, whatever he owns, or his other business that's not properly protected with all the corporate formalities, okay? Anything Joe Smith owns personally, they'll be able to go after. Now, what if you form the Joe Smith LLC and your investment property is in the Joe Smith LLC? They can only sue and attach to what the company owns. That's the power of an LLC. All right. Now, I just want to drive home insurance a little bit more because, again, it's great, but I see people relying on insurance instead of forming an LLC, and they really need both. A few weeks ago, I was called by a very nice couple. They needed some extra income during COVID, and so they did something very creative. They actually transformed the backyard of their home into a wedding venue. And it has been doing fantastic. They're getting about $5,000 a weekend, renting out their backyard to brides and grooms all over California. Great. but not in an LLC. And let's do the analysis. Okay, we now have thousands of people a year coming to their backyard. Do we think there's some risk of liability there? Well, could someone slip and fall? Could a child drown in their pool? Could someone drink too much and get hurt? Could a structure collapse and hurt multiple people? I mean, yeah, the answer is yes to all of these things. And without having their home in an LLC, they have no personal liability protection right now. Now they're not, I mean, these are clever people, so they did take one step, okay? They've been having the bride and groom purchase an insurance policy every time they arrive, all right? They couldn't find an insurance company to insure them, but they could find an insurance company to insure the bride and groom. Then they had the bride and groom list them as additional insureds on the policy. Great, okay? But there's a lot of misunderstandings there. The house is in both of their names. And the bride and groom, they don't understand. So half the time they're listing the wife only, half the time they're listing the husband, the other half of the time, okay, I don't know, too many halves, whatever. They are listing what they think is the name of the company when there actually is no company, right? In any of those scenarios, I think you have a gap in coverage and a real possible bad scenario there. It needs to go into an LLC to really get that liability protection. Okay, so liability protection, very important. You can get it from LLCs, you can get it from corporations. Briefly, what is the difference between an LLC and a corporation? Essentially, it has to do with the yearly compliance that's required. Again, you only get this personal liability protection if it's a real business. And you have to follow the business formalities and structure for it to be a real business. Corporations require a little bit more maintenance. All right, you have to do yearly minutes of the shareholders, yearly minutes of the directors. You have to issue stock certificates, yearly statements of information with the California Secretary of State, and you have to pay $800 a year to the California Franchise Tax Board. LLCs, all you have to do is file the statements of information with the California Secretary of State and pay the $800 a year to the California Franchise Tax Board. So no minutes, no stock certificates, no stock ledger. It is easier to maintain an LLC. And that is partly why, particularly with real estate investments, LLCs are so popular. Okay, well, sounds like we like liability protection, and LLCs seem pretty easy to use. How do you form one? Pretty simple. We're going to file articles of organization. We're going to get an EIN, which is a taxpayer identification number from the IRS. We'll use that EIN to open the business bank account, and then we'll file statements of information with the California Secretary of State. Okay, pretty easy, right? This is where people get into trouble, huge trouble, because it seems so easy. I will tell you, a good lawyer is going to charge $3,000 to $5,000 to form an LLC. Okay, $3,000 to $5,000 for proper legal advice on the formation of this thing. In my experience, an accountant will do it for $800. And in my experience, a YouTube guru will do it for free. Right? We all love YouTube. We love getting advice from YouTube. They're doing it for free. Why would I hire a lawyer for $3,000 to $5,000 to form my LLC? Especially since all I have to do is file articles of organization, get an EIN, open a bank account, and this is statement of information. And essentially, it's because there are so many hidden traps out there that an accountant or a LegalZoom or a paralegal or whoever have no idea about or won't take the time to advise you on. That is what you're really paying for. You're not hiring someone like me to do this simple 4-step process. You're having me evaluate various things to keep you out of trouble. So, LLCs, what they don't tell you and why many fail. First of all, can you form an LLC? I will tell you, if you are a professional and you have a professional license, such as a lawyer, accountant, most doctors, chiropractor, psychologist, okay?
Real estate agent.
Yeah, real estate agents are an interesting gray area, actually. I view you guys as professionals, absolutely, and you have a professional license. It's a bit of a gray area whether a real estate agent needs a professional corporation or not. Probably err on the side of caution, do a professional corporation. But in essence, if you have a professional license, California law is going to require you to have a professional corporation. The next thing is, can you form an LLC due to hidden license requirements? A really good example of this are construction companies. I have a lot of clients who are general contractors, and they come to me to form their company or usually fix their company. A general contractor or making a construction company, they can form an LLC. But the bond that they have to buy in order to do their work and be fully licensed is ridiculously expensive if they have an LLC. If they have a corporation, it's pretty cheap. But if it's an LLC, it's very expensive. So could they form one? Yes. Would an accountant or some other professional form it for them? Sure. But they're going to run into problems. Construction companies should be a corporation. So just one example of where you can get into trouble unwittingly. The other issue is, do you own the LLC? Well, you're probably looking at me going, Andrew, of course I own the LLC. I came to you, I told you I wanted to buy an LLC. I have the real property. We're going to put in the LLC. What do you mean, do I own the LLC? And I'm going to look at you and say, well, are you married? Because if you're married, we have community property laws here in California. And even if you're the one creating the LLC, it's probably not just your LLC. It's probably half yours and half your wife's. If you have a business partner, it's probably half your, or 1/4 yours, 1/4 your wife's, 1/4 his, and 1/4 his wife's, right? I don't care what the stock certificates say or the membership certificates. Community property laws are going to trump those. So what state did you live in when you formed it? Where did the money come from when you formed it? What contracts are in place between you and your spouse? Is the company in a trust? What type of trust? Okay, this is so far beyond just filing articles of organization. Do you even own this thing? Do you own the land? Okay, and Tommy's probably going to smile during this one. And we're talking about forming an LLC and putting real property into it, right? Do you own the real property? Is there a mistake in the chain of title? All right. Did someone make a mistake in the deed? So we have to do a correction deed now to make sure that you have marketable title. Did you buy the real property? And when you bought it, did you buy an owner's policy of title insurance? Or did you rely on the bank's lender's policy? And that's probably good enough. A lender's policy does not insure you. I would never rely on a lender's policy alone. I see Tommy there. Do you want to say something on that?
Yeah, well, you're absolutely right. I mean, a lot of times, especially with cash buyers feel, oh, I don't need a owner's policy. Or if they're just doing maybe they're paying cash, but doing a small portion seller carryback, they're like, oh, I don't need a lender's policy, or I don't need an owner's policy. You gotta remember the owner's policy covers the property itself for that transaction, ensuring that everything is up to date to that transaction, and that there's nobody else that has ties to it. A lender's policy protects absolutely nobody except for the loan on that property.
So I love title insurance too, by the way. All right. When you got the property, did you get it from a gift? Did you get the real property from a divorce? And did an attorney review the divorce judgment to make sure it's actually yours? Did you, well, I'll share one quick story. I had a client last year. She got her property in the divorce. She had an attorney. Her ex-husband had an attorney. The ex-husband didn't pay his divorce attorney. Instead, he had the divorce attorney put a lien on the home, and then he gave her the home subject to a $60,000 lien. She didn't know. Her divorce attorney didn't know. When I went to do the estate plan, I found out. We were able to correct it, okay? Do you own the land? It's not simple. Did you perhaps act as a trustee of someone else's trust and you gave yourself the property, but you didn't have legal authority to give yourself the property, and now you've stolen from a family member or a friend of yours? That happens all the time too. So do you own the land? And then what are the tax consequences involved of putting property into an LLC? All right, we have this beautiful tax code provision, IRC 121. I love this, this tax code. And most people don't even know about it. But when we buy a house and we live there, let's say we bought it for $400,000, and then this crazy COVID spike in market prices happen, we sell that $400,000 property for $800,000. That's a $400,000 gain, right? We should be paying capital gains tax, a 15 to 20% capital gains tax on that $400,000 of profit that we got from the sale. The only reason why we don't is because of IRC 121. If we are a married couple and we live there, we have a $500,000 coupon protecting us from that capital gains tax. If I was married, but my spouse passed away 3 to 15 to 20 years ago, I only have a $250,000 coupon. If I'm single and I sell the house, I have a $250,000 coupon. Okay, but it's a very powerful coupon, which is why we don't associate capital gains tax with the sale of our home. But if you have an investment property, you don't have that coupon. So we need to make sure that we account for that when we talk about putting real property into an LLC. If we put your primary residence into an LLC, you will lose that coupon. Okay, putting your investment property in there, you're good to go. You didn't have a coupon anyway. But if we put your home into an LLC, you no longer own the home. The LLC owns the home, and we lose that capital gains coupon. Very important. Please do not form an LLC without proper legal advice. You also lose what's called a step-up in basis, by the way, which protects against capital gains tax after you pass away, allows your children to sell the property without capital gains tax. That's a more complicated discussion, but also related. There's also Prop 19 implications. All right, state property taxes. It is very common for mom and dad to have bought a property back in 1960 or whatever, and they are paying $800 a year for state property taxes on their property right now. Okay. Whereas if we bought a house for the same value this year, we could be paying $10,000 a year in state property taxes. Whether or not you think that's fair is a different discussion. That's what the law is, right? Now, before February of this year, we had a wonderful exemption from reassessment. You can give your primary residence to your kids and not be reassessed at all. You can give an investment property to your kids and you have a $1 million coupon against reassessment. Fantastic. We lost that with Prop 19. Okay, we don't have it anymore. We have a very limited exclusion for the primary residence going to the kids. The mom and dad had to live there at the time of death, and the kid who inherits it has to actually move into the home. Very difficult to use it, but it's still there to an extent. It's not unlimited anymore, but we still have it. But for investment properties, it's gone entirely right now. And it can make a huge difference. So if you have someone who they want to have a second home, either for their child to live there or to rent it out and get the rental income, either way, and they want to protect against reassessment in the future, then they need to talk to an attorney. First the problem, then the solution, okay? If we have an $800 a year tax bill and it jumps to $10,000 a year because we give it to our son or daughter, and our son or daughter plans on living there for 30 years, okay? That's a $9,200 a year difference. That's a $276,000 mistake because we didn't talk to an attorney first, okay? So what can an attorney do for you? The attorney can form an LLC and have you buy the property with the LLC. You cannot buy the property yourself first and then transfer it to an LLC. It will not work. You have to form an LLC first, buy the property with the LLC, and then with proper guidance from an attorney, you can avoid the reassessment. Tommy asked me to explain this in detail. I went to do it, and when I timed myself, it took 45 minutes just to explain how this all works. So I'll just put a little note here. It's the interplay between California Revenue and Taxation Code 64 and the case Ocean Avenue LLC versus County of Los Angeles. But for my realtors out there, I repeat, if your client is looking to buy a second home or a commercial property, do not let them buy it personally. Please have them call me first or another attorney first, form an LLC first, and then buy the property. You could save them $200,000 to $300,000 by doing that. All right. It's what they don't tell you why many fail. How do you get out of it? It is so easy to form an LLC, right? Articles of organization, EIN, bank account, statement of information. So easy. California would love to collect $800 a year from you. They're not going to put a big barrier there. Have an LLC, you've been doing it for a while. How do you get out? Okay. You own the LLC with another person. You both want to dissolve the company. How do you do it? How do you divide the profits? What if one of you put more money in than the other? What if one of you put more work in than the other? What if you later acquired a third owner? How do you dissolve the company in a way where everyone is fairly compensated? How do we even determine the value of the company? In fact, I'll tell you, when I draft operating agreements, I like to have one appraiser selected by one party, one appraiser selected by the second party, and if those appraisers can't agree, they at least agree on a third appraiser, and now we have a company value. It's not an easy question to solve. So form the LLC, how do we get out of it? Also, do you actually have liability protection simply by forming the LLC? Probably not. You need an operating agreement. Notice when I said, how do you form an LLC? I did not say you needed to create an operating agreement. You don't. You do not need an operating agreement to form an LLC. But if you want any liability protection, then I suggest you get an operating agreement. The operating agreement, it establishes all the rules for your company. It would be very difficult for me to go to court and talk to the judge and say, Judge, they love the business. They followed every corporate formality and they have all the business receipts and they have liability protection. The judge says, okay, well, what are the rules of the company? What is the basic framework of it? I just thought they would ignore that part. They're good, right? So if you want liability protection, you need an operating agreement. And it not only gets the liability protection, explains how do we dissolve this thing one day. It also goes into how do you stay in control if somebody leaves? Do we have a right of first refusal? Please meet Kenneth and James. They're best friends. Kenneth's dad passed away without a trust, and Kenneth is 18 and suddenly inherited a couple $1 million because no trust was there. And so, okay, California's gonna let him get a couple million at age 18. His best friend James says, you know what? Let's buy a house on the beach. We'll rent it out as a vacation property. Let's form an LLC ourselves without an attorney's guidance because, you know, bro, why waste the money? You know, it's just an attorney. We can do this ourselves. And so now they have a company. And I want to ask if James dies or sells his interest to an outside investor, or gives his share of the company away, or gets a divorce, who will be Kenneth's new business partner? Does Kenneth even know? Probably not. So we want an operating agreement. We want a right of first refusal here, because if anything happens to James, Kenneth wants the right to buy his shares. Kenneth wants full control of the company, right? And then there's all these creative things that you can kind of do here to make sure that it all works out in the way you want. An additional document is called a buy-sell agreement. We buy life insurance on each other's lives. So Kenneth has a life insurance policy on James's life, and James has a life insurance policy on Kenneth's life. Okay, so if James dies, then Kenneth gets $1 million in cash, which he can then use to hire appraisers, figure out the value of the company, and buy Kenneth's shares. So he doesn't have to deal with Gloria, whoever this lady is that James accidentally married, right? Because She looks tough. She would eat me alive. I think she'd eat Kenneth alive too. In addition to that, with the operating agreement, who pays the taxes, the utilities, the insurance, the repairs? How do we share the profits? Who has signing authority? Can each of them act independently? What if James is incapacitated? Does Kenneth's business fail because now we don't have James's signature? Because I don't think James is getting an estate plan in his 20s. He just doesn't have that education yet. If it's a vacation property, when can the owners vacation there? When can their families vacation there? And then again, when we dissolve it, how do we determine the value? Okay, we talked about buy-sell agreement. Okay, what if you don't maintain your LLC? What if you don't pay the California Franchise Tax Board? What if you don't send in those statements of information? What happens? Well, you cannot legally do business. You will be suspended by the California Secretary of State or the Franchise Tax Board or both. I've seen this happen 4 times in the past 2 months. Happens a lot. You cannot legally do business. You cannot enforce contracts. You cannot defend yourself in court. You cannot sell, transfer, or exchange any real property. You can't maintain the right to use your business name. And the list just keeps going on. I think honestly, not being able to defend yourself in court is what scares me the most. You can't enforce your contracts, you can't defend yourself, and obviously no liability protection if you can't defend yourself, right? So we want to make sure that we maintain the LLC. Also, just kind of a fun fact, if you own a corporation and it's suspended by the government, you can face 1 year of imprisonment for not following these formalities. So it's definitely important. Okay, I'm an estate planner first. So I have to do a quick plug for estate planning. Why do you need a trust if you're a business owner? It's very simple. We don't just pass away, right? We tend to become incapacitated, whether that's Alzheimer's or dementia, or getting into a car accident and being physically incapacitated. Who has the ability to sign your name if you can't, so that when you recover, you have a business to get back to? How will you do payroll? How will you enter into new contracts? How will you pay your current vendors? You need an estate plan if you have a business, because something could happen to you and you want that business to be back, to be there when you get back. And then also, when you pass away, who's going to get your company after you die? You need an estate plan. And it's nice when you have an attorney who kind of does both, because I'm able to understand the interplay between the two. And part of that interplay is funding your business into your trust. I like to describe a trust like a box of cereal, right? When you're alive and well, the cereal is in the box, and the box is in your pantry. And I'm essentially writing the instructions on the box. That's what I'm doing. I'm writing that trust, I'm writing the instructions on the box. And throughout your whole life, whenever you get more cereal, you can put in the box. Whenever you need to pay an expense, you just pour out a little cereal and you pay that expense. It's still your money, it's still in your pantry. Eventually, you're going to get sick or you're going to pass away. It is still your cereal, it's still your box, but now it's in your successor trustee's pantry. Could be a child, could be a sibling, could be a professional, whoever it is, it's now under their control, right? It's in their pantry, but they have to follow the instructions on the box. They don't follow the instructions on the box and they steal your cereal. You hire someone like me, we sue them, we go take the cereal out of their pantry, we go take their cereal, okay? But I could write you the best box in the world. If you don't put your assets into it, it's going to do absolutely nothing. And so whenever I encounter most estate plans I review, the cereal's not in the box. The cereal's all over the counter. All right. And whether that was an attorney drafted box or a paralegal drafted or a LegalZoom drafted or just we Googled a form, it's so much more than just the instructions of the box. We have to make sure the cereal's in it. And businesses are probably the most difficult asset to put into the box. So you really need good legal advice to make sure that it gets in there. Otherwise, you could buy a trust and end up in probate court anyway, simply because you didn't put the cereal into the box. And so I wanted to save plenty of time for any questions that may come up. Since I'm a little early, I'll just throw the quick word out there. ADA compliance is very important these days. A little left field, I know, but very, very important. California is very pro rights for everybody in California. That includes the handicapped out there. And we're seeing a huge uptick in litigation for companies that have websites that are not ADA compliant. Meaning, can someone who's blind or have some other disability, are they able to read and access and understand your website? You are required to make sure that they can. There are several companies that specialize in how to do this. I can recommend several if you want to give me a call. But we're seeing a lot of random lawsuits where just, a couple of handicapped people figured out all they have to do is go to your website, see it's not ADA compliant. They have an attorney sue you and it settles for 20 grand, and then go on to the next one. And California wants businesses to make their websites ADA compliant. So I just want to put that warning out there. Other than that, this is me. I'm Andrew. I would love to answer any questions that you might have.
I have an easy question that maybe would be dumb, but I've been so curious about this all the years that I've taken signatures. First of all, lots of people don't even know what their capacity is when they sign. We have a lot of problem with that, even if they know they have an LLC. Is there a big difference between using a title like member or authorized signer? Those are seem to be with the standard corporation, we're used to president, vice president, secretary, that sort of thing. Is there a big difference, similar difference between signatures and an LLC?
Great question. Yeah, so what are the different, there's all these different titles when it comes to signatures. What's the relevance of these different titles? If you have a corporation, usually it's the officer that's signing. So the president, the secretary, the vice president, or the treasurer is going to be the one signing. Usually it's the president and the secretary. If you have an LLC, we don't have officers like that. Instead, we have members or we have a manager. And so you'll see them signing as either members or as a manager, depending on the operating agreement. And if they don't have an operating agreement, here again is a potential problem. Did they have signature authority? We don't know how they're supposed to be signing. And so that's where authorized signer is probably coming up for you. Are they an authorized signer? Because are they signing correctly as an officer of a corporation, or either a member or a manager of an LLC, or do they not have a business and they're signing their personal name as a sole proprietorship or whatever?
I haven't had it backfire too much, but I was curious what the standard differences were in those, signatures. Thank you for that answer.
Yeah, you bet. And it probably won't backfire until a lawsuit happens. And then it's going to be a real big problem for those people.
They always ask me, what am I? I'm like, I don't know. You have to call somebody and ask them.
Yeah, and there's no way for you to know. Basically, an attorney needs to review the corporate documents or the LLC documents, and then they get.
That was my underlying question. Was there something I was supposed to know that I just didn't?
No, just can't give legal advice, but here's 2 or 3 attorneys that I know, and can either of them be helpful to you?
We have a lot of deeding where they'll do a contract under their name and then tell us stand by for their LLC, and then they name a lot of them the exact same name as the address of the property. So I know a lot of people are having more than one LLC. Is there a benefit to holding each property? I guess just the same benefits multiply, right? That
is a great question. Thank you for asking that. All right. If I have my home, investment property number 1, and investment property number 2, do I need 1 LLC or 2? Probably 2. It would make sense to have 2, because you're going to put 1 investment property in the first LLC and the other investment property in the second LLC. Because otherwise, if you get hit with a big lawsuit and both properties are in just 1 LLC, well, that lawsuit can attach to both properties. Even if we only slipped and fell in the first property, we can go after the second one too, because it's owned by the same owner. But if we have two different LLCs, we're getting more liability protection, right? We have different buckets. And so, yeah, it's another $800 a year to the California Franchise Tax Board, but the liability protection could be huge. The other reason to have more than one LLC, I have a rather wealthy client that owns a RV park, and it's worth many millions of dollars. It makes sense for them to have two LLCs, one LLC to own the land. So if anyone slips and falls on the land, the most they can get is the land. And then the other LLC to manage all of the employees of that property. And so that way, if there's any lawsuit from an employee for maybe unlawful termination or whatever, they can only go after the value of the business and they can't go after the value of the land. We're able to segregate it because it's in two different buckets. Really good question, Mary Jane. Thank you.
I know you said that they need to acquire any LLC. Can you sell your property to your LLC? Is that a workaround, for better term? I'm not trying to look for a slippery way. I'm being honest. Is that a legitimate workaround? Can you sell your property to your LLC and bring it in that way?
Oh, to avoid reassessment?
No, when you said you couldn't, if you've already acquired property, then you can't LLC, you can't do it after. Can you?
So thank you for that question. She's asking, I mentioned that it's bad to buy a property in your name alone and then transfer it to an LLC. Can you, instead of giving it to your LLC, can you sell it to your LLC to avoid the negative tax implications? And the answer is there's no difference here. I want to make clear, you can still buy a property in your individual name and you can still transfer to your LLC either by gift or inheritance or through a sale. There's no obstacle to that transfer. Talking about reassessment, and we're talking about passing it down to the next generation and your state property tax bill not skyrocketing from $800 a year to $10,000 a year. And the only known way right now to effectively do that is you buy the property with the LLC, and then when you pass it to the generations, you're giving a certain number of shares to a certain number of people of that LLC in order to avoid reassessment. Very complicated, but
I see.
Yeah, in layman's terms is you are transferring the business that owns the property, not so much just transferring the property, right, at that point. So because you're transferring the business, the property is not changing hands and therefore will not reassess. All right, any other questions for Andrew? I was going through the chats. I didn't notice anything in the chats. But I think everybody should have the ability to unmute themselves. So if you do have a specific question that you would like to ask, by all means, feel free to ask. If it's a one-off and you want to wait and ask him direct, you do have his contact information, not only in the video here, but it is in the chat right now as well. And some of this kind of piggybacked off of Prop 19, so I will throw out, we do have a video in our storage for Prop 19 as well that talks to some of those implications and what you cannot do anymore and what you can do, et cetera. So feel free to go and look that up. But I would say is if you do own a business, if you have residential income properties, commercial income properties, et cetera, and you don't have a corporation formed or an LLC yet, Andrew is definitely the one you want to talk to next to find out how you could protect yourself. Andrew, man, I learned quite a bit. I took quite a few notes. I have a half a page of notes on a big notepad here today, so doesn't happen too often, but I learned a lot just listening to your presentation. So again, I know that your time is valuable, so thank you for taking the time out to join us and share your knowledge.
You bet. Thank you for the opportunity. And I just want to close by saying that is my cell phone on the screen there. And please feel free to text or call me at any time. I remember how intimidating it was to hire an attorney before I was an attorney. You'd always get the secretary and they couldn't answer your question. They couldn't quote you a fee, and half the time you wouldn't get a call back. And yeah, I work every weekend because I'm answering phone calls all the time. But I never want to change. I want to be accessible. So please feel free to call or text anytime. Thank you for the opportunity, guys.
I reposted your contact information again in the chat, so it's the last one there for everybody. Yeah, again, thank you for taking the time out and walking through this. We look forward to, having you on each week to share your knowledge and the other topics and stuff that we do as well. So, Mary Jane, did you have an update for next week before we say goodbye?
No, I was going to continue to tempt Andrew and all of you to continue to join us. We've been getting a lot of questions about the potential of a short sale market, even a baby one after all the forbearance and things that have been given. There have been some good indicators lately that it may not be anywhere near as much as we feared, because property value went up at the same time. So they're saying even the people who are behind have an average around 80,000-ish left in an average range after. So there will be some sales, but standard sales where they just catch up. We have already started seeing forbearance cleanup. We've got 3 or 4 of them in escrow right now where we have seen HUD had filed a second for the entire amount. If it was a HUD insured loan, they put it to the end of your loan by having you sign, and they recorded a second trust deed for the amount. They are $0 deeds of trust, and the demands are good for about 90 days. So they're not making us chase them too much to pay them back. So we're starting to see a little bit of that. The back and forth that you're following, I'm sure, between the national level release of the moratorium, the state level, the county level. San Diego this week announced that they were going to go ahead and release theirs. I had a client ask me about San Diego releasing the moratorium. And I said that in every other case, and maybe I'll say something wrong here, Andrew, and you'll straighten me out, but the way that we have been taught so far is if there's 2 laws, the more restrictive one is the one that has to be followed. So I'm guessing the state of California one is going to stand, and then the national one. But in anticipation of that, we have been setting aside some classes. And the next 2 that we have coming up for you are Short Sales 101. I'm just going to go ahead and get that recorded and tell you how to counsel people and the types of things you'll hear from them and how to help them save face, how to pick a good short sale negotiator if you're not going to do it yourself, and what a good escrow company can do for you in those cases, and a good title company, because part of the package you have to turn in is a preliminary title report and an estimated net sheet. Also, CAR released a week or 2 ago a complete education package on rent relief. So we're going to be doing that as well this month. We are going to be teaching you specifically how to get landlords and tenants made whole. They did change the law where they used to say you could only get 80% recovery. They are now ready to pay out at 100% recovery. So we're going to teach you guys how to do that, a program straight from CAR. The week of the first, so that'll be, and then Samantha, our favorite, one of our favorite TCs, is going to come in and do a class at the end of the month called Details Matter. What's missing from your file that you're later going to wish you had in there, like an operating agreement. And that type of thing. So next week is Short Sales 101, and then Details Matter, and then Rent Relief. So that's where we are for the next few weeks. Keeping in mind that we have Labor Day weekend. I can't believe summer's wrapping up. And it never does in Temecula until the end of October. So we're in the throes of the heat right now. So we do stay on the line after we release you all. We do stay on the line for a few minutes to see if we can do anything that's unrelated to this class or related to this class. I think with that, Tommy, I think we're, Andrew, once again, thank you for your insights, and we're very happy to have you on the classes this now and in the future. Tommy, anything else, or I think that does it.
That was it. But yeah, thank you, everybody. Again, if you guys have any questions, you can reach out to Mary Jane and myself. If you can't find Andrew's contact, we could definitely get you in contact with him. And we hope that you'll join us next Monday. Thanks again.